the UK's Information Commissioner's office has just fined Marks & Spencer for £350,000 after the retailer admitted to accidentally emailing customer data to the wrong people. But what does this mean for you if you shopped at Marks & Spencer, and how do you know whether your details were a part of the breach? Well, let me explain. Marks & Spencer is one of the largest retailers in the UK with over 1,400 stores nationwide. And it's also one of my favorite places to shop because they have some amazing food. So when I heard that M&S had been fined for sending customer emails to the wrong people, I was shocked. This is exactly why we have laws like GDPR in place. And for a company like M&S to get this wrong is concerning, to say the least. So here's what happened. In June 2021, M&S outsourced its email marketing platform to a company called Connective. When transferring over the customer data to Connective, M&S accidentally sent an email to over 450,000 customers containing other customers' personal information. And in April 2016, Marks & Spencer accidentally published customers' email addresses online, which meant that they could be accessed by anyone. Clearly, Marks & Spencer needs to take its data protection obligations more seriously. Under GDPR, organizations can only process personal data if they have a lawful basis to do so. The most common lawful basis is when processing is necessary for the performance of a contract. For example, if you buy something from Marks & Spencer, then they will need your name and address to fulfill that contract by delivering the goods to you. It is also very common for companies to rely on legitimate interests. When it comes to processing personal data, legitimate interests is a lawful basis that allows businesses to process personal data. If it is in their legitimate business interest to do so and the processing is not overridden by your rights and freedoms. For example, sending you marketing emails can be a legitimate interest provided it is in the company's legitimate interest to send you those emails and it is not overridden by your rights and freedoms. For example, if you've asked them not to contact you, when Marks & Spencer sent those emails to customers containing other customers' details, they didn't have a lawful basis to do so. That is because it was not necessary for the performance of any contract, and it was in their legitimate business interest to send emails to customers containing other customers' details. It seems likely that Marks & Spencer was trying to use the legitimate interests lawful basis to send the emails but failed to carry out the necessary checks. This is why they've now been fined. The ICO's investigation found that Marks & Spencer failed to implement appropriate technical and organizational measures to protect customer data, which resulted in this data being shared with unauthorized third parties on multiple occasions. The ICO also found that M&S didn't do enough to assess the risks of the transfers taking place and did improperly consider the impact on people's rights. The investigation also found that M&S failed to comply with a number of the ICO's recommendations following the 2018 incident, meaning similar issues were able to occur again. The ICO's report states that Marks & Spencer should have carried out data mapping exercises in order to identify all the data that was being transferred to Connective. This would have allowed M&S to determine what safeguards were needed to ensure the data was kept secure. However, Marks & Spencer failed to do this. Instead, Marks & Spencer took Connective's word that they would implement adequate security measures. Unfortunately, Connective did not implement the appropriate technical and organizational measures to keep the data secure. As soon as Marks & Spencer realized that there had been a breach, they should have immediately closed down access to the database and notified the ICO within 72 hours. However, Marks & Spencer didn't do this. They did unclose the database down straight away and instead opted to try and identify the emails that contained the data breach. It took 3 days for M&S to identify the emails and another 4 days to notify the ICO, which means that Marks & Spencer was in breach of its notification timeframe. In total, the ICO has fined Marks & Spencer £350,000, which is the maximum fine that they could issue. The ICO considers that this fine is appropriate because the company showed a lack of commitment to data protection. The ICO says that the fine should encourage M&S to do better in the future. In a statement, the ICO said, "We all have the right to expect our personal data to be kept safely and securely, and Marks & Spencer did not take the appropriate steps to ensure that this happened." At the time of the incident, Marks & Spencer was already aware that the data controller they were dealing with had inadequate safeguards in place. Despite this, no steps were taken to mitigate the risk. Marks & Spencer failed to comply with the ICO's previous recommendations and guidance, and was slow to investigate and notify us of this breach. We have therefore issued the maximum possible fine in this case. A spokesperson for Marks & Spencer said, "We're deeply sorry that this happened. We fell below our own high standards and the standards expected of us by our customers and the ICO. We've eased our data security and privacy practices across our systems and we're working hard to maintain the trust Our customers have placed in us for over 140 years. If you're wondering whether your details were part of the breach, unfortunately it's difficult to say without knowing what data Marks & Spencer was sending to Connexon. What I would recommend doing is checking your recent emails to see if your VA received any emails from anyone else containing other people's names. If you do find any, then it's likely that your data was part of the breach. Even though no financial data was involved in this breach, it's still really important to check your credit reports for signs of identity theft. You can get your credit report from all 3 major credit agencies for free. I'll leave links to them in the description below. I think this case shows that even large established companies can fall foul of data protection rules. It also shows that outsourcing data to a third party doesn't necessarily make things safer. If anything, it introduces more risk. It's vital that companies have robust contractual and technical safeguards in place when dealing with customer data. It might also be worth reminding yourself of your rights under data protection laws. For example, you have the right to ask companies not to contact you for marketing purposes, and you have the right to ask for your data to be deleted. If you want to learn more about your rights, I'll leave a link to the ICO's website in the description below. If you want to learn more about data protection and privacy, then I've got plenty of videos covering these topics. And if you want to stay up to date with all the latest privacy news, then remember to subscribe. If you found this video useful, please remember to leave a like and comment to let me know what you think. Thank you so much for watching, and I'll see you next time.